is 21P 1002, Foster v. Foster. Ms. Foster, you are first, and you can go to the podium and make your argument.
Good morning, member of the panel. May I please the court? For the record, my name is Jessica Eisler. I'm here to argue on behalf of myself. First, I would like to say I am very nervous, and I hope that I'll be able to do everything right.
I'm sure you'll be fine. I just want to make sure that you get that microphone a little bit closer to your mouth. There you go. Come closer to it so that we make sure that we are able to record what you're saying.
Okay. Under the American Constitution, everybody have a right to a fair trial, which I didn't receive. The main and the most important reason for me to be here today is because I want my daughter Isabella back. I am outstanding U.S. citizen with no criminal record, no record of domestic violence, no record of mental issues. I don't drink, I don't do drugs or alcohol. I have not done anything to deserve my right as a mother to be taken away and the bond with my daughter to be broken. I have always been the primary caretaker for Isabella since the day she was born. I love my daughter and I miss her. I worry when I see her and heard that she's been neglected under the father's care. I am sad when she tells me that she misses me and asking me, Mom, when I'm coming home. As a mother, I want and deserve to be a part of my daughter's life. Taking care of her, cooking for her, taking her to school, be a part of activities, taking her to the doctor's appointment when she's sick, and being there for her, that I always have been. And just being there while she's growing up to be a young woman. She's my only child. She's 12 years old. She needs her mother. Seeing her twice a week at the visitor center doesn't benefit any of us. Without legal presentation and with the accusations by Mr. Foster, which have pursued the court over time, the consequence of it and repercussion have grossly exceeded anything that I could have done. I am from Brazil, and I am strong and opinionated. I have a way to speak and expressing myself. I was the same way when me and Mr. Foster met. When I see something wrong, I will speak up. When I see our daughter has not been properly taken care of, as you can see in my trial transcript, I was portrayed as unfit mother, unstable, or without any proof. My words were taken and twisted against me, with false accusations, such as that I have mental issues. The GAL pointed by this divorce case, Mr. Harry Summer, he stated is no evidence of the mother being born.
Excuse me, ma'am. The GAL report is impounded, and it wasn't, was it submitted as an exhibit at trial? I can ask opposing counsel that, but
they did, but they also called me and asking me to to get the GAL report and bring it?
No. I'm asking you what happened at trial. Our question to the parties was whether or not the GAL report was an exhibit. We don't see it on the exhibit list, and in any event, it's impounded. So I'm going to ask you not to quote in open court from the GAL report.
Okay. As you can see in my trial transcript, I was portrayed. Oh, yeah, I already did that part. We filed
You're doing fine, and I interrupted
Okay,
you. But
that's
just
okay.
skip to the next section.
Yep. If any outspoken and passionate person is mentally ill, we all can be called crazy. I will always stand up for myself and for my daughter. I want to make sure my daughter is safe, healthy, and happy. I never stopped Mr. Foster from being a part of Isabella's life. But he did not stop until he had my daughter entirely taken away from me. My reputation was destroyed without of spite. I gave birth to Isabella, and I have every single right to be a part of her life, as he does. On the second issue, the marital property should be reevaluated and split fairly. Without the father held responsibility for the missing mortgage payments and the unpaid water bill, the $20,000 addition from the net flat shall be equally divided between parties. That's overlooked and never fair to be a satisfaction of both parties. Last but not least, the 7 times shares of the marital property, as everything else, should be equally divided. That was never done. In conclusion, there isn't enough evidence that I should not be allowed to be reunited with my daughter. I am seeking this honorable court to be consider all the facts and make the decision that truly fair. When splitting the marital property and timeshare, and the most of all, I am seeking a custody decision to be only to be the best interest of my minor child. The custody to be granted to me with an appropriate parenting time for Mr. Foster.
Excuse me, ma'am, are you talking about physical custody or legal custody or both?
Both. I would hope this decision would be ensure physical and mental well-being of my daughter going forward. That's all what I have. If the member of the court have any question for me, I'll be happy to answer them.
Do you have any? No questions.
Thank you.
Thank you. Ma'am, you can just sit at the table until the argument's over. It's okay.
Good morning, and may it please the court. Excuse me. Attorney Alfred Faris III for the appellee. Part of my fear today is I believe that what the appellant is looking for is relief for the ongoing litigation. Because as this panel may know, she had filed a request to go forward on a modification which has been ongoing while this appeal has been pending. And that modification, as the appellant had stated, has resulted in her having supervised parenting time. It has really swayed significantly since the entry of the judgment of divorce. And that's based upon the facts and circumstances of everything that's occurred since. So I understand what appellant is looking for today based upon the judgment, but I believe it's more based upon what the current temporary orders are.
All right, so remind me that the judgment had supervised or unsupervised parenting?
Unsupervised.
That's what I thought. Okay,
And now
so,
it's supervised at a supervision center.
okay.
And the court may be wondering, somewhat how the court got to where it is. And I want to leave off where we are today, but as of the date of the judge.
Yeah, we consider it, what we have before us is the snapshot as of the day of the judgment, and we don't consider matters outside the record.
So in looking at the record appendix, page 47, there was a finding of fact. It was finding of fact 18, and it was August 29th in 2019. And this is really what leads to the swaying of the court towards changing legal custody. And there's a specific finding of fact that mother was instructed not to disenroll the child from the child's school system. And she did, in violation of the order. And there was a hearing, and the court made a finding and granted father sole legal custody based upon that. Because the court found that mother was incapable of discussing this matter with father and acting in the child's best interest. And that's what we're here for, the child's best interest. I've read the brief. The brief talks about a real advantage standard, which is a removal standard, not applicable to this case. But we are just left with best interest.
The brief also raises a prior history between the parties, and there was we can see from the docket, and we can take judicial notice of the docket, that there was a previous 209A. What are we to make after Vaughn and after the amendments to the statute? What are we to make of the fact that the judge didn't make any findings concerning the prior history, made no findings as to what had occurred, and made no findings as to the best interest of the child?
And I think that comes down to what's presented at the time of trial.
Well, there was some testimony that wasn't stricken from the wife about past events, and there was a denial by the husband, which creates a fact dispute which we as an appellate court are not permitted to resolve.
And I believe that it comes down to an issue of credibility and what was presented. Ms. Foster, when she filed her original brief and appendix, she had included a transcript of a deposition of the guardian ad litem. To answer the court's question, the guardian ad litem report was never admitted into evidence. It was stale. It was completed in 2018. This trial was in 2020. There was a prior order for an update of the guardian ad litem report that never took place.
What had us perplexed is that there's a reference, I think on page 33 or 37 of the transcript, to the fact that the GAL report is in evidence.
It was, and I believe that was a misstatement by trial counsel, to be quite honest, as to whether or not that was. A guardian ad litem report is typically admissible subject to a motion to strike. And
it was filed but not admitted, is what you're telling us.
It was filed with the court. It is part of the court file, but it is not just like an affidavit would be in a court file unless it's brought forward at trial. There were only 5 trial exhibits. I believe that would have been transmitted with the record appendix. On the issues of the property division, I think the court did an...
Well, before we get to the property division, what do we as an appellate court do with an apparent dispute of fact regarding this type of prior history with respect to the custody determination?
I think this court defers to the lower court, and the lower court doesn't make a determination.
The trial judge didn't resolve it. He said there was no pending 209A at the time of trial. That's all he says.
Correct. And I believe that what this court can infer from that was that he did not believe that this rise to the level of a Vaughn analysis of whether or not there was a incident or a pattern of domestic violence that would have resulted in a presumption against custody to one or another party.
You know, I find that aspect of the statute very interesting, because I understand that you need a serious incident or pattern to get to a presumption. But what if there isn't a serious incident, but there is nevertheless an incident? What does the statute require in that instance? What is the judge supposed to have done in that instance?
I don't think the statute requires the judge to do anything other than weigh the credibility of the parties and make a determination as to what's in the best interest of the child.
Right, but we still don't have any findings by the judge and determination of best interest in light of those findings.
Well, I believe we do have findings as to best interest, but in light of whether or not there was an actual incident of domestic violence, I agree, there is no finding on that.
It's an interesting conundrum under the case law and the statute.
It
that's
is.
all.
And it is not bright line law for the lower court to follow in either direction, unfortunately.
Okay.
The modification, was that filed by the mother?
It was.
Okay, and does it concern just the custody issues, or
It does.
everything? Okay, it doesn't concern the property?
Property division is not modifiable
That's right.
post-divorce.
Okay.
And with the property division,
Counsel, before you get to that,
Sure.
just, could I go back to, you had mentioned the Vaughn case, but I noticed looking at your brief, it doesn't look like you addressed the Vaughn case. Is there a reason that you wouldn't have addressed that?
I just don't believe that in my reading of the transcript, and I wasn't trial counsel, I don't believe that it was a central theme. I don't believe it was something that was brought forward in terms of real evidence in either direction, for or against, and I don't believe it was part of the best interest analysis.
Okay, so your position is that there were, as I counted, there might have been maybe a half dozen references in the transcript to physical abuse, someone being struck, and so forth. That wouldn't be enough, in your view, for the judge to have made a further inquiry or maybe made some credibility finding at that point?
I think the judge did make credibility findings. In terms of further inquiry, I don't think the judge is permitted to make further inquiry. I think it's up to the litigants to present the matter. We are dealt with in the probate and family court, a court of almost 85% pro se's on one side or another. It's a systemic problem, a problem we've tried to address, and it's a problem that results in cases like these being brought before the court.
Yeah. I understand your position when it comes to something like property division. It's a tougher issue, would you not say, when it comes to custody and the independent obligation of the court to ensure the best interest of the child?
I do. I would say that when it comes to the best interest, I think the judge did do a very thorough job in evaluating in terms of whether or not there was any reference to the domestic violence. I submit that there was no in the actual findings of fact. We're also dealing with a single justice calendar, with a justice that's been involved in the case both before, the pretrials, the motions, the emergency hearings. We expect the judge to act in a vacuum. It's not always possible because you go in knowing what you know going into that case. But when he wrote this decision is based upon the evidence that's presented on the day of trial.
You had wanted to talk about property division.
Just briefly, on the property division, I believe that we're dealing with a 5-year marriage, for all intents and purposes, based upon the Act to Reform Alimony of 2011. We look at the date of marriage as being the date that the marriage started and the date of the filing and service of the complaint for contempt. It's a short-term marriage. The goal of the court in a short-term marriage is to put the parties back in a position that would closely resemble where they were prior to the marriage. The timeshares in particular were all premarital assets that husband owned and that were listed on his financial statement. And the court awarded him the assets that are listed on his financial statement. So I certainly think that that's something that was addressed by the court. With regards to the $20,000 and the difference, that's a judgment that the court made based upon the facts and circumstances, based upon the super contribution arguments that he found credible in terms of how much money was taken out of father's account and put on as a down payment on the home, the loan that he took from his mother, and in addition, he had paid all the operating expenses of the home, which in comparison to if he was paying a child support order at that time, significantly outweighed that. So there was a super contributor argument that the court found as well, and case law says it doesn't have to be with mathematical precision. He made a decision that a $20,000 adjustment was appropriate under the circumstances. So I think it is justified both by the facts, the evidence, and in the actual judgment itself. Any other questions?
No further
I
questions.
appreciate your time. Thank you very much.
Thank you very much. That concludes our argument in this case. All right, I'm informed that we have a problem with the live stream. And so I'm just going to take a moment now to pause and see whether that's been resolved. If it hasn't, we may take a brief recess to permit. We all right? Okay. We never lost the recording, so your arguments have been fully recorded. All right. The next case is 22P0376, Fry versus West. All right, sir.
Good morning.
Did I pronounce your name correctly?
Anyways, fine.
No, what's the correct?
Fry.
It is.
Yeah.
All right.
Yeah.
All right. I went with my Latin.
Okay. Good morning. May I please this court? My name is Peter Fry. I'm a member on the planning board in a little town, Holland. It's about an hour west from here. If I may first try to tell you how we got here, and then how I see it, and then maybe how the land court sees it.
Your time is yours, and you can use it however you want. I want you to know that we have read every word of your brief and
great.
opposing counsel's brief, so we do know something about how it got here.
Okay, great.
But it's your time.
Okay. The only question here is a very narrow one. The question is whether I have standing as a member on the planning board to appeal a constructive approval. The law is very clear. Under Chapter 40A, Section 17, any municipal officer or municipal board has standing to appeal a decision. The legislator didn't narrow it down. It's very all-encompassing. Oops, sorry.
It's fine.
Sorry.
Don't you worry.
Sorry.
It's all
I
right.
shouldn't use my hand to talk, right?
Just keep them to the side. You'll be fine.
Okay, so eventually the Supreme Court narrowed it down. And the Supreme Court narrowed it down to municipal officers who are involved in planning and zoning. So, for instance, somebody from Conservation Commission is a municipal officer, but they don't have standing, or even a town council doesn't have standing. Anyway, after I filed my appeal, the land court conducted an online hearing, and the judge informed me that I don't have standing. And then I disagreed with the judge, and he was nice enough to allow me 2 weeks to file a memorandum. And he said he bases his dismissal on the Harvard case. And in the Harvard case, there were many different plaintiffs, but not one plaintiff actually met that requirement by the Supreme Court to have any involvement in creating laws or any involvement in zoning and this sort of things. There was an obscure committee. It was called Harvard Square Advisory Committee. And the court didn't really know how to go about it because there was nothing in the record which would give the court any indication of what their duties and authorities were. And it says in that decision from Harvard that the court actually looked into town charters and things like that and couldn't find anything because there was nothing on record. And I think that's what the land court, where the land court got the idea from. Because what the land court did after they read my memorandum, the land court dismissed it anyway. And I think my memorandum was convincing because all of a sudden it was not the question anymore whether I'm a municipal officer. The question was whether I'm just a member on the planning board or if I still am a municipal officer. It's kind of weird. Anyway, they're actually, the land court actually based their dismissal on Section 211 of the general bylaws of the town of Holland. And in that Section 211 of the general bylaws of the town of Holland is almost verbatim, language borrowed from Chapter 41, Section 81A, and Chapter 41, Section 81A has a title, Planning Board, Establishment, Membership, Tenure, Vacancies. And it basically gives a statutory scheme how to establish a planning board in a town. And for instance, if you have less than 10,000 people, residents, you may have a planning board. If you have more than 10,000, you have to have a planning board. And in there, for instance, it says you need to have at least 5 members. One member, the first time when it's established, one member is elected for 1 year, another member for 2 years, 3 years, 4 years, 5 years. And then thereafter, every 5 years, every member comes up for re-election.
So I would like, if I could interrupt for a minute, I'd like
absolutely.
to ask you a question, which is that you are appearing here because you've disagreed with a decision of the board or the constructive approval by the board.
Yes,
correct?
yes.
And so the board has not approved you are not acting on behalf of the board. You are not here for the board.
That's a very tricky question. All the other members are on my side. They are not like opposing me being here. They're all on my side.
Let me, I don't think that's in the record, and we can only deal with what's in the record. Let me put it a different way. There wasn't a vote of the board to send you here to speak on its behalf.
There was a vote taken authorizing me to file that motion, which is a request to strike my opponent's attorney, I don't know his name, his brief, because he doesn't really represent anybody. He never even talked to any members on the planning board, not once. And we took a vote that I can actually file that motion, informing the court that my opponent doesn't really represent anybody.
All right, proceed with your argument then.
Okay, so Chapter 41, Section 81A uses the term member, referring to municipal officers 13 times. 13 times. Then we have other chapters. For instance, Chapter 41, Section 1, town officers to be elected, tenure, uses the term member in connection of a planning board 5 times. Then we have another chapter, Chapter 40A, Section 9, Special Permits. That section uses the term member, referring to municipal officers 14 times. So,
Sir, let me just interrupt you there for a second, because I want to try to get to the heart of what's going on here. So, and let me ask you this hypothetical question, okay? This is a case of constructive grant of
Yes.
relief, because the
Yes.
planning board didn't take any action because you didn't have a quorum
Yes.
as a result of a couple things, but ultimately, a member of the select board was also on the planning board, he resigned, you didn't have the quorum,
exactly.
relief is granted. All right, let's change those facts just a little bit. What if the planning board, let's say 4 out of 5 members voted to grant relief, and let's say you were the one member who voted against granting relief? Are you saying that you would then have a right to go to the land court and oppose what the other members of the planning board did?
Your Honor, I think the legislator actually intended that outcome, and here's why. In these little towns, usually you will find a very tight-knit, small group who run the town, and they actually vote in favor what benefits themselves and their friends. And if you have one person with integrity who actually wants to bring some change, I think the legislator intended that outcome, that one person can actually file an appeal. This is not the situation we have here, but I think the legislator actually intended that outcome. It has never been done. As far as I know, I mean, I read many, many cases studying this issue to come here and make sense, or at least try to make sense. And I couldn't find one case where actually one member on the planning board filed an appeal and presented an argument here. But that doesn't mean that it can't be done.
Isn't it more appropriate that it be left to abutters to appeal? If the people who are most directly impacted by relief having been granted, isn't it up to them to come forward?
Absolutely. That standard of aggrieved party is always all in there, even in Section 17. But Section 17 explicitly, and it's supported by case law, says that municipal boards and municipal officers can actually file an appeal without being personally aggrieved.
But doesn't that suggest that the board has to appeal as a body and that individual members do not have standing?
That's actually a good question too, but again, it explicitly says municipal officers and boards.
Right, but the legislature easily could have said municipal officers, municipal boards, or members of a municipal board. But the fact that they delineate between municipal officers and boards, to me, suggests they intended the board has to appeal as a body, because the board acts as a body.
Actually, that's not my idea. Even in Harvard Square, it has language that neither one of the dependents nor any board meet the standard in that case. But that doesn't mean that you cannot file
I think
an appeal.
the board here would have standing to appeal, but as a body, not as individual members.
You know, Your Honor, I respectfully disagree because the case law says different.
Which case law says differently?
Hold on. That will be in the case Planning Board of Marshfield versus Zoning Board of Appeals of Pembroke and another, 427 Mass. 699, and that will be on page 701. It's a case from 1998.
So the yellow light tells you you only have a
Yeah.
minute or so left.
Geez, I just started to having fun here, so. I mean, do you have any other questions?
No, I don't.
Okay, thank you very much for listening.
All right, thank you very much.
Good morning, and may it please the court. Connor Mullen from the firm KP Law, representing the appellee, municipal appellee, the planning board for the town of Holland. There is a narrow question before this court this morning, and it is whether the land court properly dismissed the appeal of the constructive approval for lack of subject matter jurisdiction, specifically because on the basis that appellant is not a municipal officer as is contemplated under General Law, Chapter 40A, Section 17. The Massachusetts case law shows that the answer to this question is an unequivocal no. In drafting the statutory language of General Law, Chapter 40A, Section 17, I would invite this panel's attention to the use of municipal officer or board, and invite this court to recognize the significance of those two terms having different meanings. And if this panel were to follow the reasoning offered by the appellant in this case, that an individual member of a board would qualify as a municipal officer, surely merely by virtue of their membership on a municipal board, that would, to me, seem to erode the distinction between the terms of municipal officer or municipal board. And under principles of statutory construction, when two different words are used within the same statute, those words are to be read to have distinct meaning where possible.
If the board had brought the action as the board, would that be cognizable?
Yes. Yes, Your Honor. So if the board had appealed and had, through a duly authorized vote and had moved to appeal, then yes, that would be, as the municipal board identified in the statute, that would be a party that would have standing. I would also offer by analogy the possibility that with respect to municipal officer, there could be a situation where, say, a local zoning enforcement officer issues a denial of a request for zoning enforcement. Perhaps then that request goes up to a zoning board of appeals, and the zoning board of appeals overturns that denial. Perhaps that zoning enforcement officer would have be a municipal officer with a substantial interest in the enforcement of the zoning bylaws, such that they would be a municipal officer under General Law, Chapter 48, Section 17. And I would distinguish that analogy from the facts of this case, where we have just an individual member who, by virtue of their membership and by the activities and duties and responsibilities that appellant engages in as part of that membership, that alone cannot confer standing as a municipal officer. As I said in my introduction, that would, to me, seem to erode the distinction between municipal board and municipal officer as used in the statute.
Well, counsel, putting aside the standing just for a second, doesn't Mr. Fry make a really good point, though, that here we have a planning board that's supposed to be addressing the issue of special permit, and it's deprived of the opportunity to do that because a member has resigned, there's no longer a quorum, relief is granted as a matter of law. So the planning board's never had a chance to speak on this issue. There's never been a public hearing on the issue. So residents haven't had a chance to come in and voice their concerns. And then when we get to this stage, the planning board has not even authorized you to represent them in any of these court proceedings, and according to Mr. Fry, you haven't even consulted with the planning board, and yet you're representing the planning board. I mean, isn't that somewhat of a problem?
No, Your Honor, and I will, I'll address, to me, I see that as 2 points, so I'll address those in sequence. With respect to whether the planning board was deprived of the opportunity to, pursue an appeal, I would offer that they were not, because there would be nothing that would have stopped the board from scheduling a open meeting in conformance with the open meeting law, and then voting as a body to pursue the appeal, to pursue an appeal of the constructive approval under General Law, Chapter 48, Section 17. That did not happen in this case, but I would offer that there's nothing that would have prevented the planning board as a body from doing so. However, the planning board's failure to, or either failure or decision to not do so, does not then open up a avenue for appellant to pursue that same route towards appellate relief as an individual member. So that's my response to the first point of your question.
How could they do that if they didn't have a quorum?
So I would say at a, not at that same meeting, but the planning board could, within the time frame under 40A, Section 17, could have scheduled a follow-up meeting and then voted.
Was there a quorum within the time frame under Section 40A? We don't even know that from the record.
I can't say for certainty, but I mean, if there had been, that could have been an avenue that they could have pursued.
So could you address the issue of authority? Because if the planning board did not authorize the defense in this appeal, who did?
Yes, Your Honor. And that was the second part of the question that I was...
Yes, you were going seriatim. We understand that.
Okay. So two points I would like to make with respect to us as town council, our authorization to represent the planning board here. First, the authorization does not come from the planning board. It comes from the Board of Selectmen. That's under, and this is, it may be part of the record, I can't say for sure, but it's under Section 6.3 of the, 6.3.1 of the general bylaws of the town of Holland, which just provides that the selectmen shall annually in June appoint a member in good standing, a member of the bar to serve as town council for the term of 1 year. The immediate subsequent section in the general bylaws, section 6.4.1, describes the duties of town council, which include, and I'm reading verbatim, the prosecution of actions or proceedings by or on behalf of any town officer, board, or committee, as such when the selectmen, having determined that any rights or interests of the town may be involved, therein so shall request. So under the general bylaws to the town, that authorization comes from the Board of Selectmen, not from the planning board.
But you read that rather quickly, but don't you need specific authorization to represent the town in a particular action?
So there's, I mean, this was started after the request of, and I don't have, the exact, correspondence with me, but in terms of the authorization, it comes from the Board of Selectmen when they, request town council to handle a matter. And I'd be certainly happy to, follow up and submit.
So what you're saying essentially is that the selectmen can authorize a defense which may or may not be in accordance with the wishes of a particular board?
That is precisely what I'm saying, Your Honor. I would also...
So you can see the frustration of Mr. Fry, though, because this kind of strikes right at the heart of what he's saying. We have a member of the select board resigning from the planning board that triggered the loss of the quorum, and now presumably it's that very member of the select board who's voting to authorize you to defend the constructive grant of relief. So in other words, it's sort of like this one member is sort of exercising a veto power over the duly appointed members of the planning board.
I certainly recognize how that could give cause to frustration. However, I would offer that the solution, if any, would be required to that, just speaking hypothetically, would not be to read Chapter 48, Section 17 in a way that creates a new class of standing as an individual member. To the extent that any solution may be required to address frustrations with respect to what Your Honor just described, I would say that would be a matter of policy determination for the town to take at the local level. Again, not to try to establish a new route to appeal under 4817, where that route did not previously exist.
So you're saying the relief is in the political process, not the legal process?
Precisely, Your Honor. With respect to that, and there may be some other legal processes that, Mr. Frey may be able to pursue. I mean, that's outside, at least in my opinion, of the scope of the question, but I will, reiterate that what is not the solution would be to, allow an individual member without, authorization to do so to pursue.
It's been represented to us today that all the planning board members agree with him. Was this argument made in the land court?
I can't say definitively. The first I had seen of it was in the post-brief motion that appellant had filed, but I can't say definitively to the court.
All right. I don't think we have the memo that was filed in the land court. I do see that it's on the docket. But in general, as we know, issues have to be raised in the trial court in order to be raised here.
And I would also just...
So in the meantime, the property owner, who was the beneficiary of this constructive grant of relief, has been able to sit on the sidelines and not do anything to defend the relief that he or she obtained. And essentially, the town is carrying the water, footing the bill for the landowner through this action and the land court action. Is that right?
In this particular case, Your Honor, my understanding is that the town made the decision to more actively defend the constructive approval than might otherwise, which might be different than the decision that it might reach if we had a more engaged private defendant or one represented by counsel. I can't speak to the inner workings or rationale behind the town's decision. I mean, because that's a matter of policy for them to determine. But in this case, we as town council are handling the active defense, at least with respect to this stage of the proceedings.
At no cost to the property owner.
I can't say definitively, but I mean, there's...
In other words, you're being paid by the town, is what I'm...
Yeah, as
driving
town
at.
council, yes. And as a last point, I just would like to offer to, kind of round out the issue on authorization. Two decisions in particular I would invite this panel's attention to, both fairly old. In the decision of Board of Public Works of Wellesley versus Board of Selectmen of Wellesley, it's a 1979 decision from the Supreme Judicial Court. The court said, "It is conventional learning that a municipal department is not permitted to bring suit for the town without specific authorization from the town or from agents entitled to act for it, unless, indeed, there is governing legislation conferring the power on the department." In this case, I would suggest that no specific authorization had been granted for the planning board to appoint its own counsel, and that, therefore, there not being a standalone separate piece of legislation authorizing the planning board to act unilaterally, that there's no issue with our representation as town council of the planning board under the facts that have led up to this stage of the proceedings. Again, there are specific situations perhaps where a local board may be entitled to appoint their own counsel. I can't speak to those specifics, but I will say that this is not one of them because no direction or authorization to do so has come from either a statute that I am aware of or from direction from the selectmen. And I will otherwise rest on my briefs, but does the panel have any other questions? Okay.
We do not.
Thank you all
you
for your
very
time.
much.
Thank you.
All right. The next case is 22P0259, Rice versus Town of Brewster. Attorney Shapiro.
Thank you, Your Honor. May it please the court, my name is Alan Shapiro. I'm an attorney at a law firm called Sanduli Grace, and we represent the appellants in this case, who are 3 Brewster police officers named Daniel Langtot, Brandon Rice, and Morgan Vermette. The case is about what someone who goes to a police academy gets paid while they're at the police academy. The decision of the Superior Court and the position of the town seems to be that unless you're actually appointed as a police officer before you go to the police academy, then the economic provisions of Chapter 41, Section 96B don't apply. And it's the position of the appellants that when a municipality appoints people to positions in which they will become police officers once they graduate from the academy, which is what happened here, then they are required to follow the provisions of 96B, which says that they get paid the lowest wage for the position to which they were appointed, which is to become a police officer. I think there's some maybe fundamental misunderstandings that are in the Superior Court decision and somewhat in the town's argument. The idea about police powers, nobody has police powers until they graduate from a police academy. The fact that in Foxborough and in the Cambridge case, those people were appointed police officers before they went to the police academy, it's really a ministerial appointment. You can't exercise police powers, and 96B is quite clear on that, until you graduate from a police academy.
Well, counsel, let me just ask you this. Are you asking us to apply the Foxborough case or extend the Foxborough case? In other words, the Foxborough case, by its terms, referenced police officers. You were appointed as a police officer. But these individuals were appointed as cadets. So are we applying the case or extending the case?
What I'm asking the court to do is to apply what this court in both Cambridge, excuse me, and in Foxborough said was the purpose of this statute, which is to make sure that people who go to a police academy to become police officers are going to get the basic pay of a police officer. I agree that factually the fact that in Cambridge and Foxborough, the people had been previously appointed as police officers before they went to the academy, that's a factual difference, but that was not an issue in those cases. In this case, the town essentially...
Is that clear in Cambridge, the Cambridge case?
I think it is. I think that was assumed
All right.
in Cambridge.
You know, the irony is that we do have a published criminal case called Vidulas, which says even if you're a cadet, there was a cadet or a student officer who arrested somebody, and the Supreme Judicial Court held as a matter of law that they were acting as a police officer. I understand your point about the statute here, and it appears that it was amended at one point to make it much clearer that you could not exercise police powers. Have you done any statutory history research on the statute?
I did a little bit, yes, Your Honor.
And is there anything in the statutory history that would illuminate your argument?
I don't really think so. I think the statute was originally enacted as part of the police consolidation in 1991 when the state police absorbed a bunch of other police departments.
Well, that's back to 91, but if I look at the statute book correctly, it was first enacted in 1965, and that remains something of a mystery.
I'm not really familiar with it.
Okay, okay.
But one point, Your Honor, about the cadets, I don't know what municipality that criminal case was in, where they were cadet, where that officer was a cadet.
I don't think it matters.
Well, it does, Your Honor, because in Boston, Cambridge, Waltham, those are places I'm aware of, there actually are statutory provisions for the position of cadet.
It's not what the court relied on.
Excuse me?
It's not what the court relied on, but
Okay.
let's go forward. What impact, if any, does the employment agreement have on our analysis? As I read the employment agreement, it says that once a student officer has graduated, they will become a police officer.
Yes. I think that's the point. I think that if you look at the definition of full-time police officer in the Academy regulations, 550 CMR 3.02, a person who receives an appointment to a permanent full-time position in which he will exercise police powers as a police officer. Functionally, that's what happened here. They received an appointment as cadets or cadet dispatcher, which was really a non-existent job. Nobody ever worked in any of those titles. But that was a position that was a permanent full-time job, and they will exercise police powers once they graduate from the academy.
So what if instead the municipality had merely said, we're going to sponsor you?
That's a whole
We're not
different...
going to hire you, you're not going to
That's-
be an employee, but we're going to sponsor you.
That's a whole different thing. Nobody, people who are sponsored, there's no obligation for anybody to pay them.
And
And I think there's a conflation here between when a police department sponsors someone to go to a police academy as opposed to hires them and sends them to a police academy and is paying them while they're at the police academy. These people were not sponsored. They were sent and met the definition of full-time police officer in 302 in that definitional section. Sponsored candidate, there's a definition, but that's for somebody who's not employed by a law enforcement agency.
is the cadet position, does the cadet position fall under the CBA?
No, Your Honor.
I noticed that civilian dispatchers are listed on the wage rate. Is there any collateral litigation of which we should be aware, such as unfair labor practice proceedings regarding the creation of this job description?
Not that I'm aware of, Your Honor. As far as I know, I mean, frankly, the job description there is no job description. There's a job
There's a job and a bylaw.
that, with no description as to what it does. Nobody's ever done anything in those jobs. I have to say, it seems like those were artificial designations. I don't know what the intention was, but it clearly, the town took the position that because we called them cadets when we sent them to the police academy, we can avoid having to pay them what the statute says, which is the regular wage of a police officer.
Let me ask you this. If we were to agree with you, is there a risk of some unintended consequences here? I mean, if we've got small towns and they try to be fiscally creative, they want to hire police, bring them on board, but they don't have a lot of resources to do it. If we require essentially departments to hire people as police officers, if you're hiring them, they have to be as police officers, and they have to be paid whatever the rate is under the collective bargaining agreement for a new police officer.
Right.
Would that discourage departments from actually hiring and go the route that you had just discussed about the sponsorship, and that we'd have people going to the academy and not getting paid at all?
First of all, if a municipality is concerned about what they have to pay people when they send them to the academy, they can negotiate in the collective bargaining agreement for a rate for people who are at the academy. There are many contracts that have a designation of student officer, Title 0, whatever they call it. Whatever the lowest rate in the collective bargaining agreement is, if there is a collective bargaining agreement, then that's what somebody's supposed to get paid if they're hired and paid by the municipality to go to the academy. If they want to sponsor them and not pay them, and then take a chance when they graduate that they'll still go work for that department, they could do that.
Maybe I misunderstood this. Are you saying that if the collective bargaining agreement had a designation for, let's say, cadet in it, that would be okay?
Yes.
Why would that be? I don't understand that.
Because the collective bargaining agreement covers police. I mean, assuming that the collective bargaining agreement, the bargaining unit that's encompassed by the collective bargaining unit is police officers, then the lowest wage in that collective bargaining agreement, regardless of what they call it, would still apply. If they called it student officer, for instance.
Yeah, but then the only difference is that it seems that you're saying, well, if it's in the collective bargaining agreement, then that's good. But if the very same thing is done by a select board, that's not good. That's inconsistent with the statute.
Because it's avoiding the responsibility to pay the wages of a police officer. And by definition, if you have a collective bargaining agreement that covers police officers, the lowest wage in that collective bargaining agreement is what would apply.
The difficulty with that position is that the statute says, provided that such person shall be paid the regular wages provided for the position to which he was appointed. And you're saying the position to which your plaintiffs were appointed was that of police officer, not student police officer. So I am a bit perplexed as well. I would have thought that your argument would be that they have to be paid as a police officer.
If the collective bargaining,
A police officer upon graduation.
if the collective bargaining agreement covers police officers, there are a few that also incorporate civilian jobs. But if the collective bargaining agreement I don't know what the collective bargaining agreement here says, But if a collective bargaining agreement covers a bargaining unit of police officers, which is what most do, then the lowest wage in that collective bargaining agreement is what would apply when people are at the police academy.
Right, but I don't understand your argument that they could create a new category for cadets or student officers.
If they negotiate with the union to have a designation called student officer,
I mean, I thought your argument was the statute protects the right to receive wages that a regular officer receives while they're at the academy.
well, regular officer in the context of a collective bargaining agreement that only covers police officers, whatever they call the first step in that collective bargaining agreement is what would apply
Right,
to when people are at the
but
academy.
you're saying that it can exclusively apply only to recruits, cadets.
They could have a designation called student officer in the collective, some do, in fact, called student officer, and that would be the lowest wage in the collective bargaining agreement and what people would get paid when they're at the academy. Student officer is, everybody who goes to an academy is called a student officer, regardless of whether they have police powers, whether they were appointed to anything. Everybody's a student officer.
After your clients graduated from the academy, did the parties execute a new employment agreement?
No, they became covered by the collective bargaining agreement.
So it was just that higher approval form is the only,
They were sworn in right after they graduated. They were sworn in as police officers and became part of the bargaining unit. There is some language in those individual employment agreements that may conflict with what's in the collective bargaining agreement, but I would assume that the collective bargaining agreement would supersede that.
Let me just ask you one more question. Each of these officers now, when they were seeking employment, they signed individual employment contracts, presumably satisfied with the terms and conditions of those contracts. Are they not bound by those contracts? Is that meaningless?
I think the contracts are somewhat adhesive because they applied to be, they did everything that one would do to become a police officer. There was advertisements for police officer. There was an exam for police officer. They applied for police officer. The background checks were done to become a police officer. They did what it takes to go to the police academy. They graduated from the police academy. Some of the terms and conditions in the employment agreement are the same as the statutory provisions, a one-year probationary period, no just cause, you can be terminated essentially as an employee at will, but they would still be, they're still part of the bargaining unit of police officers once they're sworn in as police officers. So I think if there were a conflict between those agreements and what's in the collective bargaining agreement, I would assume the collective bargaining agreement would supersede that. There are provisions, for instance, about how many hours they would work, and
That agreement does not purport to continue once they're sworn in as police officers. That's an agreement for a student officer, right?
well, it has language in there about probationary period and working a 40-hour shift, and you get overtime after 40 hours. That
Well-
may not be the same as what's in the collective bargaining
I
agreement.
see.
Well, my question's more, I'm focused more on the amount of their hourly wage, okay? So my point is, when they signed those individual contracts, they were satisfied with that hourly wage. Then they become police officers, a few years go by, and now they're not satisfied with the hourly wage that was in that contract that they're no longer operating under anyway. So my point is, isn't there some sort of a waiver lurking here? I mean, if they were satisfied at point A and now we're at point B, they're no longer satisfied, aren't they bound by the contract that they entered into?
They were given these contracts in two cases, one case the day before they went to the academy, another case the day they were going to the police academy. There's no evidence these things were ever negotiated. I just don't think a waiver argument would apply. I'm not sure the town even made that argument, Your Honor.
Okay, thank you.
Thank you very much.
Good morning. May it please the court. Paul J. Hodnett, representing the town of Brewster. I'm a partner in the firm of Rubin and Rudman. I think, and I would direct the panel's attention to the case that was decided last Thursday by the Supreme Judicial Court in DeMacy versus the Commonwealth of Massachusetts. The SJC had an opportunity to restate how statutes should be interpreted. And essentially what the plaintiffs are doing in this particular case is what the Secretary of the Commonwealth did in that particular case. They're attempting to persuade you, and they attempted to persuade the Superior Court to actually read into the statute something that is not there. The statute in question has 5 paragraphs. It is, for all intents and purposes, a training statute. The first paragraph deals with the appointment of individuals for the first time. Paragraph 2 deals with individuals who are already police officers and they have in-service training or they get promoted. Paragraph 3 deals with intermittent and reserve police officers. Paragraph 4 deals with giving the committee the authority to essentially waive the training requirements for those individuals, presumably who are already trained out of state, so they don't have to take the training offered at the academy in Massachusetts. And paragraph 5 deals with if you don't complete the training, you can't be a police officer. The focus of this case is paragraph 1.
Well, let me ask you this. Unlike the DeMacy case, I mean, that involves the Secretary of the Commonwealth reading into the statute language that he had discretion as far as whether or not someone should be able to register as a lobbyist, and the language just wasn't there. But, I mean, wouldn't you agree that this statute, there is some ambiguity in how it's written, isn't there?
I don't believe so. Again, this particular case that's before you concerns paragraph 1. Paragraph 1 in the first sentence states that individuals, before they can perform police powers, have to go to the academy. In the last sentence, it says the individual will be paid to which the position they were appointed. There's no factual dispute here. These individuals were appointed as police cadets. And to the question that you asked earlier regarding the collective bargaining agreement, if you look at paragraph 1, it says individuals, when they are at the academy, they're exempted from coverage under the collective bargaining agreement. That's specifically included in the statute. So it has no application to the 3 plaintiffs in this particular case. The individuals were in fact appointed as cadets. The town had a right to do that, consistent with their personnel bylaws. They were paid according to their personnel bylaws, and the plaintiffs make no claim that they were not paid appropriately.
So I'd like to, though, to go over the first sentence with you of the statute. But before we do you agree that the employment agreement says that if the candidate successfully completes the academy, that they will be appointed a probationary police officer?
If they, I believe the wording of the employment agreement says they will be appointed after completing all education requirements required by the town. And then, assuming they do that, they would be appointed as police officers as they were in this particular case.
All right. So
all of the plaintiffs were appointed after graduating.
we agree that then that there's no dispute of fact that the appointment is automatic if they complete the educational requirements.
Well, if they complete the educational requirement, there's a question as to whether or not, and it's never applied in Brewster, as to whether or not the reference in the employment agreement to educational requirements only refers to the police academy.
But
There may be other
leaving that aside, whatever the educational requirements may be, and in this case it happens to be the academy, they're going to automatically become police officers on probationary status.
Assuming there is no other conduct that the town could use not to appoint.
Assuming good conduct. So the first sentence says, every person who receives an appointment to a position on a full-time basis in which he will, not does, which is your point. They can't exercise police powers then.
That's right.
But in which he will, future tense, exercise police powers. So even if we call this an appointment as a student officer or cadet, it is clear from the employment agreement that if they satisfy good character and the educational requirements of the town, that they will exercise police powers. So why does it matter whether we call them a cadet or a police officer if they will exercise police powers upon successful completion of the educational requirements?
I don't think the name that you use to identify the individual is controlling. The controlling sentence in that statute is the last sentence.
Okay.
Where it says, the position in which he or she would be appointed is clearly they were appointed not as sworn police officers, but as cadets, and they were paid as cadets.
Don't we have to read that last sentence in the context of the first sentence?
No, I don't believe so.
Okay.
In my opinion, a town, like any other employer, has a right to set the terms and conditions of employment when they bring in a new hire. And in this particular case,
When they
they
bring in-
hired them as cadets. They identified in the employment agreement what they would be paid and paid them accordingly.
I think you meant when they bring them into a position not covered by a CBA.
Right. But even if they were covered by the CBA, paragraph 1 says they're exempt from coverage. Even if there was a reference in the CBA, they're exempt from coverage under the first paragraph.
Except as to wages.
It doesn't say except as to wages. Again, the last sentence deals with to the position they were appointed.
Well, the provided that section, let's follow the hypothetical. Let's say there were a CBA with a wage rate for a student officer. It says, provided that such person shall be paid the regular wages provided for the position.
To which they were appointed.
To which they were appointed.
Exactly, and that's my argument, is the appellants are attempting to read into the statute something that is not clear, and I would suggest to the panel that in fact the language is clear, unambiguous, and should be enforced. And in the lower court, this argument was made, and the Superior Court would not, and declined to read into the statute that requirement.
Okay, so you're saying that the statute guarantees that when people are when they've been hired by the town in some capacity, it guarantees they will be paid while they're at the academy, but it just doesn't guarantee they'll be paid as a police officer. Is that right?
Exactly, exactly.
But they
They
could just-
be paid at the position to which they were
They
appointed.
could appoint them to any position? They could slap any sort of label on their appointment position and pay them at that rate? They can make it up.
I suppose they could apply any,
So how does that make sense? So let's say you have two recruits. one gets an appointment letter saying, we're appointing you, just as the plaintiffs got in this case, we're appointing you as cadet. The second one gets an appointment letter, like in the Foxborough case, we're appointing you as a police officer, and then the rest of the letter is the same as the letter that the plaintiffs got in this case. In the real world, what functionally is the difference between those two people? They both go to the academy, right? They do the exact same thing, and then upon graduation, they become police officers, right?
Well, as I understand, I want to be sure I understand the question. In the real world, in your question, one of your examples was essentially the Foxborough case.
Right.
In the Foxborough case, 2 months before the police officer was sent to the academy, there was no dispute. He was appointed as a police officer.
The question is, in the real world, what difference does that make? What additional functions and duties does he perform because he was appointed as a police officer as opposed to, because the letter says he's appointed to police officer as opposed to cadet?
In terms of actually going to the academy, it has no difference as it relates to the two police officers. But in the real world, the scenario you outlined does in fact impact on the ability of an employer, whether it be a municipality, the University of Massachusetts, or any other state university who has a police force. It impacts on their ability to contract with the individuals who are going to be appointed to the academy.
So in the real world, the only difference is the amount of wages that each person gets paid, right? I mean, so it's the label.
That's correct.
And your position is the statute doesn't treat all those people similarly? The ones who are going into the academy to become regular police officers can be treated disparately, depending on the label that's put in the appointment letter?
Well, that's the way the statute is drafted. It focuses on the appointment, not upon anything else.
So if, let's say we take 3 people, all from the same town. One gets a letter saying you're appointed as a police officer. A second gets a letter that says you're appointed as a student police officer. And a third says you're being appointed as the janitor.
I'm sorry, I didn't hear the third.
You're being appointed as the janitor, and your wage rate is going to be $10 an hour. All 3 people go to the academy. All 3 get treated differently because of their appointment letter?
No. In the first instance, the individual is sworn as the police officer. In the next 2 instances, they're not sworn as police officers and appointed as police officers. So yes, there would be a difference with regard to number 2 and number 3.
And in your view, the statute permits that?
Yes.
Okay, I understand.
I'll take Justice Sullivan's hypothetical. Let's say person 2 and 3 bring an equal protection challenge. What would be the town's argument as to why these people are differently situated and entitled to be paid at different rates?
The argument would be that the individuals were paid according to the position to which they were appointed. And
are they performing any different duties or doing anything differently?
That's correct.
What's correct?
That even though they were all going to the same academy class, the town, depending upon the hiring agreement, could pay them differently. I suspect that would not happen, but they could do that.
But, I mean, can you see how that would not withstand an equal protection challenge if, in fact, they're performing the same duties? But your position is the statute permits that?
The statute permits to pay them at whatever position they were appointed.
Is there a rationale for why the town of Brewster would do this, apart from, evidently just saving some money at the front end? Is there anything beyond that?
The town has traditionally appointed people in this fashion, and in fact, since this case was litigated, they've continued to appoint people in the same fashion. that they would not be sworn in as police officers by the Board of Selectmen, because that has to happen from the board. The agreement with the cadets is done by the town administrator, as it was in this case.
Oh, okay, I see.
If you look at the employment agreement, there is an employment agreement signed by the town administrator. It's one of the exhibits in the appendix, in which the terms and conditions of employment are contained. Once they graduated from the academy, the individuals were then sworn in by the Board of Selectmen as probationary police officers and keepers of the lockup, which is the traditional name applied in Brewster to a first-year police officer.
Is that just a ministerial act of the Select Board, or are they actually exercising some discretion as far as whether or not they ultimately want to hire these individuals?
I don't believe it's ministerial. You're going to need a vote of the board. I'm not aware of any case in Brewster where the board has failed to appoint a police officer, to appoint someone as a police officer who has in fact completed the academy. But in theory, as I mentioned earlier to Justice Sullivan, if in fact there was something else beyond the education that the board was aware of, they would have a right not to appoint. They're not required to do that.
So you're saying essentially there's two decision makers here. One is the town administrator,
Yes.
and then you have the Select Board.
Yes.
They're both at different ends of the hiring
Yes,
process.
the town administrator signs the agreement before, and the Board of Selectmen acts when they've graduated from the academy.
But presumably, the administrator has committed the Select Board to hire them as probationary police officers if they satisfy the requirements of the agreement.
That could very well be.
All right. Well, any further questions from the panel?
Thank you.
All right. Thank you both for your arguments and your briefs. That concludes the in-court portion of our sitting for today. We will recess and resume on Zoom. While we are in the courtroom, though, I'd like to extend particular thanks to our court officers, our clerks, our law clerks, and interns for their help in preparing for today. Thank you very much.